And we are recording. All present accounted for. Good morning, folks. The time is 10:01, and I call it February 16th. I call the February 16th, 2023 Planning Board meeting to order. We are today with us is Vice Chair Bailey.
Morning.
And we have Commissioner Washington.
Morning.
Commissioner Dorner.
Hello.
And Commissioner Giraldo.
Good morning.
And I am Chair Shapiro. Please note that the deadline for all participant pre-registration and for all submission of materials and exhibits was 12 noon on the Tuesday before this planning board meeting. Registered speakers may join the meeting with a link provided in the email provided by the planning board office or listen by phone by utilizing the call-in number provided in the email. And of course, anyone may tune in to watch the planning board meeting via live stream. If you wish to speak or become a person of record, you may use our online web form, which you see referenced on the screen in front of you. In addition to the commissioners, we are joined by our planning director, Director Chuckley, Delisa Coleman, our associate general counsel, Jessica Jones, planning board administrator, Joe Parsons, our senior technical hearing writer, James Hunt, division chief, development review division, and Kenneth Flanagan and Ryan Cron are helping us with our technology behind the scenes. Thanks, everybody. We're going to go through the order of agendas. We're actually going to follow the order as listed, I believe. That's right. So the first thing that we'll do is take up item 2. I would look for a motion to approve the draft minutes of February 9, 2022.
Move approval, Mr. Chairman.
Second.
We've got a motion by Commissioner Washington, second by, I believe it was Commissioner Dorner.
Yeah.
Any discussion on the motion? Is that right, or was it Giraldo?
No, I beat him this morning.
You beat him? All right. Any discussion on the motion? If not, I will call the roll. Vice Chair Bailey.
But I.
Actually, I forgot who went when. It doesn't matter. Commissioner Washington.
Vote aye.
Commissioner Dorner.
But I.
Commissioner Giraldo.
I'm here. Vote aye.
Thank you. Thank you and thank you. Next, we're going to go to item 3A. Supplemental legislation. This is a CB 21-2023. Chad Williams is going to be talking us through this, and I'll turn it over to you, Chad. And I think Deborah Borden, you're going to be assisting as well.
Mr. Chair,
Ms. Coleman?
yes, you didn't finish out the motion to accept the minutes.
I didn't?
We did?
Oh, okay.
Yeah,
Oh,
you
whatever.
did.
My apologies, I didn't hear it.
Oh, okay. Thank you. Thanks for checking that. So Chad, Deborah, take it away.
Good morning,
Oh,
Chairman
Raina,
Shapiro.
Deborah, take it away. Right.
That's okay. You didn't know it says Chad there. Good morning, Chairman Shapiro and members of the Planning Board. For the record, Raina Hightower. Today I will discuss CB 21-2023, which adds 2 new subsections to the transition and grandfathering regulations. Subsection O is the most important part of the bill. It allows any property in the county to access the uses permitted by the property's prior zone before the effective date of the CMA. The access to the prior use tables would be effective for 10 years. This language addresses concerns raised by the development community. Staff supports the proposed language but recommends amendments. The first amendment would be to revise the language to reference the start and end date of the of allowing applicants or a property to access the prior use tables. This recommendation has been included, just for your information, in proposed draft 2 of the County Council's bill, which is being discussed at PHED right now. Staff also has recommended language to cut off access to the prior use tables if an applicant requests to rezone their property in the future. This was also included in proposed draft 2 of the bill, which is being discussed now. Staff also recommended in our staff report for the district council's consideration that access to prior use tables could cut off after a property is rezoned through an SMA. That may be discussed at PHED committee today, as we've transmitted our preliminary staff report, but it has not been included yet in proposed draft 2. Under subsection N, that language allows an assemblage of properties inside the Beltway that were rezoned from the MXT zone to the IE zone during the CMA to develop using the CGO regulations. The properties impacted by this language are covered by CSP 14003 and may impact several adjacent properties. The language treats certain IE properties different from all other IE properties, which, as the planning board knows, compromises the goals of uniformity for all properties and could establish a de facto rezoning. Also, staff points out that the term assemblage is not defined, which is used in the bill. Staff believes the most appropriate way to develop these properties using the CGO zone regulations is to rezone the properties during the Blue Line Corridor Sector Plan, or a zoning map amendment, or a planned development zoning map amendment. Staff recommends that the planning board vote to take no position on CB 21/2023 and move forward with the suggested amendments to the district council. Thank you.
Thank you, Ms. Hightower. So, commissioners, I mean, in short, much of this we like and is a very appropriate compromise. Some aspects of this we have concerns about. I think that's why the no position. Hold on one sec. Okay. That's why I think the no position is a reasonable position for us to take on this. So, but I'm open to thoughts, questions, reactions on this. We're okay? Okay. So then I would look for a motion to accept staff recommendation to take no position with amendments.
So moved.
Second.
Got a motion by Commissioner Washington, a second by, it looked like Vice Chair Bailey, it sounded like Commissioner Giraldo.
We'll give it to Vice Chair Bailey.
Okay, all right. Okay, that was confusing, but it was good.
We will discuss that later.
Exactly.
I was gonna say, that's a pretty dangerous analogy, Mr. Chairman.
I don't even know where to go in discussion on this, but any discussion on this?
No, not at all.
All right. Seeing none, I will call the roll. Commissioner Washington.
I vote aye.
Richard Giraldo.
I vote aye.
Vice Chair Bailey.
I vote aye.
Commissioner Dorner.
Vote aye.
The ayes I vote aye as well. The ayes have it. Ms. Coleman, is that what happened? I didn't vote. Did I say I vote aye as well on the, did I not say that on the previous one? Is that what happened?
That's what I heard, but sometimes, you know, given the technology, things, I don't always hear everything, so.
All right, well, so if there's any confusion, I vote aye as well on the motion to approve the draft minutes of February 9. So that would be 5-0, just to be safe. I'm with you, I appreciate it. Next, we have item 3A2. This is another piece of legislation, state legislation, SB 526, cross-listed with House Bill 723. Ms. Borden, you want to lay this out for us?
Yes, thank you, Mr. Chair. Deborah Borden, General Counsel for the record. I have two bills to present to you today. For both of the bills, we are not asking for the commission to take a position, and I will explain why. The first bill is SB 526. It is a rather sweeping change to the state's forest conservation law. The changes in three big buckets are a huge increase, I think it's huge, in the minimum replacement requirement for forest cleared. So it would go from a minimum of a 1/4 acre per acre. So per acre of clearing, you currently have to replace with a 1/4 acre. Now, a lot of counties have already raised that from a 1/4 acre, but the proposal before us is to raise it 8 times to 2 acres if it's priority forest and 1 acre if it's regular forest. We are very concerned about raising it this high, this fast, with no phasing, no grandfathering, nothing. So it would catch development that's in the pipeline. And so, you know, once they get through, they would be, you know, counting in some cases on a quarter-acre replacement. And then by the time they get to pulling their permits, they would be looking at a 2-acre replacement requirement, which is a very significant increase. So we have concerns about that. The other thing it would do would severely limit the use of retention tree banks. That has been put on, the retention tree banks have sort of been in a holding pattern while a statewide study was being done. That study was completed, and so this amended law would allow the retention banks to be used again, but it puts so many locational requirements on it. For instance, it's saying you can't use a tree bank or you can't establish a tree bank on any land that is subdividable. Well, most land is subdividable. So what it gives with one hand, it takes away with the other. And so we have real concerns about that, because we think retention banking is a useful tool in our toolbox, and we want it back. And we want it back in a way that we can actually use it. So the other thing it does is it makes the tree variance requirement very, very onerous and really probably impossible. And so that's a major issue. If you can't get a tree variance for, say, a specimen tree that's right in the middle of your project, you basically can't develop that project. So, you know, that's a real concern for us. We are not the only counties that are concerned about it. Really, you have concerns from Eastern Shore to Western Maryland. Everyone has different issues, but we are all concerned that this is not the sweet spot that you can apply statewide and not have unintended consequences. You know, the basic issue with this is that it doesn't seem to take into account that all of the counties have other goals other than tree conservation and other than climate change. We have other goals that we need to balance in order to make this all work. You know, Montgomery County has affordable housing goals. Prince George's has economic development goals. And we need to make sure that we can balance all of those goals in a way that helps our community. So we have proposed that we will not take a position on this at this time, but we've written this and I can share my screen. I'm sorry, I meant to do that. We have written our comments so that we can turn it into an opposition if it looks like the bill is moving. What we have been told so far is that, okay, I do have the ability to share. Okay, so I'm sharing the letter that we have created so far. It's written so that we can turn it into opposition, you know, on short notice if we need to. But from what we understand, the bill is sort of subject to a lot of comments from the counties. MACO is collecting all of those comments, and it is going to be MACO's suggestion that this subject, that this bill not go anywhere this year, that we do some sort of summer study, either a formal study or an informal study, and that we get together all of the counties so that we can all have input and come up with something that is appropriate for everyone. You know, we all agree that the forest conservation law should be updated, but we've got to find a way to update it in a way that is, you know, responsive to all of the different counties and all of their needs and all of their different goals. So we are on board with that, and we hope that we can participate and contribute to that. But if it does not pan out, then we will turn this into an opposition. We will come back to you for a position. But because we're going to provide these comments to MACO, we want to make sure that you are aware of them, that if you have any questions or concerns, that we get that addressed before we send these over to MACO. With that, I'll stop and see if there are any questions.
Thank you. That's very, very helpful. Commissioners, questions for Ms. Borden?
No questions, Mr. Chairman, and thank you, Ms. Borden. The only thing I would offer, the document is entitled Position Statement. I imagine it's a template you use to communicate that. If these are just for comments, because honestly, when I was reading through it, I didn't even realize that the actual position is kind of in the right under the header. So I don't know if that's a distinction without a difference or what, but I would just flag that because this is, and I support your rationale and the way you articulated them in the document.
We could certainly change the header to letter of information, which is the same thing that we did for the cannabis bill, which I'm going to talk about in a minute. So we can certainly do that. It would be the same comments, but it would be a different header.
Okay. Thank you, Ms. Borden.
Yeah, that feels clearer to me too. I appreciate that. Any other questions from Ms. Borden on this?
Yeah, do you know why they're not allowing the banks to be permitted in subdivisions? Because for certain counties, like I'm thinking us in Montgomery County, that's going to be extremely restrictive on where we could actually site within the county. And so is there any flexibility, do you think, in the reading of the law, or maybe minor tweaks that they can make to it? And then also the other question is, I don't want to put off our environmental stewardship to other counties, but if the answer is no to that question, then is there a way to contribute or get credit for like adjacent counties if we were to take, especially for sites that might be like on the border of like the county lines, like would there be an ability to just have the conservation across the border in another county if it's vicinity wise within like the same watershed and same kind of impact area?
Well, I think the answer to the first question is that there seems to be an underlying assumption in this bill that tree conservation should be done on land that is at risk of development and nowhere else. And I think that is a false assumption. That is something that is not going to hold true from county to county. Because in your developed counties, like Montgomery and Prince George's, we are looking to preserve forests in our rural and agricultural areas. We're not looking to preserve forests in the middle of Bethesda, right? So that is, for us, a sort of a fallacy that's built into these locational requirements, and that's why, to us, they don't make any sense. Now, if you're in Garrett County, they might make sense because they have a totally different situation. They are in a different place in their sort of evolution of development, and they have different goals that they are looking at when it comes to both development and preservation of trees and forests and open space. So that's the problem. This seems to have been written for a situation that doesn't apply across the state.
Great.
Yeah, no, okay, thank you. I appreciate the elaboration.
Any other questions on this? So Deborah, you're asking us the action that you're looking for us is to transmit the comments?
Yes, just allow us to transmit comments.
Transmit comments, I mean, pardon me, but transmit comments to who?
To MACO.
Oh, okay.
So we're working through MACO on this. We are going to transmit comments to MACO. MACO is then going to compile comments from all the counties.
That's fine, I'm with you.
Basically make the case that we need to do a summer study.
Okay, so commissioners, if there's no objection, then a motion would be in order to transmit the comments as described to MACO.
So moved, Mr. Chair.
Second.
Uh,
I'll defer to Mr. Giraldo.
It's the same thing. I heard Mr. Giraldo and I saw Commissioner Washington. It's a strange day I'm having.
You don't see me?
We see you. So we have a motion and a second. Is there any discussion on the motion? Seeing none, I'll call the roll. Vice Chair Bailey?
Vote aye.
Commissioner Giraldo?
I vote aye.
Commissioner Dorner?
Vote aye.
Commissioner Washington?
Vote aye.
I vote aye as well. The ayes have it 5-0. Thank you, Ms. Borden, and we'll move on to the next item, which is also you. This is item 383. This is HB 556. SB 516 is the cannabis reform legislation, and take it away.
Thank you. Yes, HB 556 is the sort of omnibus cannabis reform bill. It is a very extensive bill. It is designed to implement the referendum that was approved by the voters in November, approving legal adult use cannabis, also known as recreational use. So we have focused on two areas: the zoning provisions of this bill and the employee-employer relationship areas of this bill. So two areas only out of an 88-page bill. So we are not, again, we are not looking for a position, because we don't really think, because we have very targeted issues that we're concerned about, we don't really think it's appropriate for us to take a position on the bill itself, because most of the bill really doesn't have direct implication on the commission. Also, the other reason we don't think it's appropriate to take a position is because not all of our delegation is in favor of adult use cannabis. And even though this bill has to be dealt with, has to be passed, because the referendum must be implemented by July 1, not everyone in our delegation necessarily is on board with it. So we want to make sure that we are not overstepping, but we do want to make sure that we get our comments into the record. And so we will be submitting this and asking for your approval to submit this to MACo, as well as into the record of the bill, so that we make sure that the people who are looking at amendments know that we have some concerns about the zoning language, in particular, the language that says a local jurisdiction may not establish zoning or other requirements that unduly burden a cannabis licensee. That phrase, unduly burden, we think is a bit vague. It does not really have a lot of case law behind it that tells you what that means in a zoning context. And we think that they could wordsmith that or maybe take that out to resolve that issue. The other issue, local jurisdiction may not prevent an entity whose license may be converted. They're talking about a licensee who already has a medical cannabis license, generally a medical cannabis dispensary, that is in compliance. But what they're saying is the local jurisdiction cannot prevent that entity from converting to recreational sales. So non-medical cannabis sales. And so we're very concerned about the way this is worded, because it leaves a lot of open questions. So we've asked them some questions, clarifying questions, because the idea that we are preventing anybody from doing anything by zoning is a little problematic for us. Zoning is not about preventing people necessarily from doing things. It's about setting parameters generally for how they use their properties. And also zoning, the idea that zoning is going to come into play when someone is already in business. These are medical cannabis dispensaries that are already there. So how is zoning really going to impact them if all they're doing is now selling to people who don't have a medical cannabis card? So we want them to think about that and explore what they really are trying, what the real intent is of that, and maybe reword it to be more clear. The other issue is, again, they have some language about cannabis licensee is not required to submit to zoning board or authority if it was properly zoned. This is the same problem as the previous thing. Again, if these are existing cannabis licensees and they're in a premises that's already, they've already been through site plan or whatever, special exception, whatever it is they had to go through, I'm not really quite sure why they think we would send them or have the authority to send them again if they're not moving, they're just in the same place. Again, they may be thinking about maybe a use and occupancy that would have to be updated. And if that's the case, they should say permit, not zoning. So, again, we're just trying to hone them in on some language issues. The other issues we had mentioned yesterday, the employment issues, and we have suggested some language and some tweaks to make that more clear in terms of the testing and whether we can do the testing. And we've suggested that they allow us to do reasonable suspicion testing, and that they indemnify employers who choose to do that, to couple testing with reasonable suspicion, because that is very subjective, but at least it's better than just relying on testing where you have cannabis that the testing does not currently tell you if the person is impaired. So if you have an employer who is doing both drug testing and reasonable suspicion together for their cannabis impairment, that it seems to us that that's better, but we should get some indemnification if we do that. We shouldn't be punished for trying to do our due diligence drug testing, in a way that's more indicative of how cannabis actually works, because it can stay in your bloodstream for 30 days. You could not be impaired, but you could still have a positive drug test at work. So we want them to think about that. And again, these are just comments that will go to NACO, but they will also we want them to go in the record of the bill, so that the sponsors have them too.
All right, Commissioner, thank you, Ms. Ward. So commissioners, again, this is, we're taking no, what is recommended is that we take no position. We transmit the comments as described, specific to the zoning issues and the employer-employee relation issues. Questions for Ms. Borden?
I do have one question, and it's regarding the reasonable suspicion provision or clause. Do we currently have a reasonable suspicion clause for other type of impairment? I don't even know what you would call it. I mean, because in essence, now this is legal, but like take alcohol, for example. If there's a reasonable suspicion that someone has imbibed more than they should have, well, I think you kind of get it what I'm saying. So do we already have standards in place for that?
Yes. So our policy right now, we have what we call safety sensitive positions. The safety sensitive positions, which include child care workers, police officers, people who have CDL licenses that drive big equipment for us that require a CDL. They are already safety sensitive. They can be randomly drug tested at any time. And those positions are identified, they're in a list, and risk management maintains that list. The other positions, everybody else, is subject to drug testing based on generally accidents. If they're in an accident, we automatically send them for a drug test. And then the question then becomes, when you have, somebody has been in an accident, even if it wasn't their fault, even if they got rear-ended and they've been in an accident, you sent them for a drug test, the drug test comes up for cannabis. That's when the reasonable suspicion would come in to say, well, did we have any reason, was the accident their fault? Were they acting erratically? Was there a reason that we would think that they were actually impaired and that led to the accident? In other words, it cannot be that the person had an accident, they come up positive for cannabis, we automatically fire them. We don't want that. And so we need to adjust our policies so that we can tie in reasonable suspicion plus the test, then we can take action, whatever that is.
No, I think that's really good. Thank you for that clarifying. So, because otherwise it could become a very arbitrary kind of decision process. So thank you for clarifying. That's it for me, Mr. Chairman.
Thank you, Commissioner. Any other questions? Okay, so I would look for a motion, and what we're doing again is transmitting comments.
Move approval.
Second.
Got a motion by Commissioner Giraldo, second by Vice Chair Bailey. And And Ms. Borden, it's clear what we're doing here. We're transmitting comments again to Mako. Is that right? And also
We're
including
transmitting
this in the
comments both to Mako and to the committee.
Mako and the
Directly to
committee.
the-
Okay, great.
Yeah.
That's very helpful. Thank you. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Giraldo,
Vote aye.
Vice Chair Bailey,
Vote aye.
Commissioner Dorner,
Vote
Commissioner Washington.
I vote aye.
I vote aye as well. The ayes have it 5-0. Thank you very much.
Thank
So
you.
we are now moving to item 3B. You know what I forgot to do under commissioners' items before we go into executive session? Commissioner Joyner, you wanted to bring up something that you had seen in the news, and I thought it would be helpful for the public to hear. So if you could take a second and talk about what you noted.
Yeah, sure. I'd be happy to. It's not me. It's actually highlighting something that the Department of Parks and Recreation is doing jointly with the county. So this morning we had a news release that came out about a program that we're beginning that's called Saturday Enrichment Academy. The goal is to help improve grades and test scores of county youth. So what we're trying to do right now is from 9:30 a.m. to 12:30 p.m. on Saturdays from, I guess it's probably in 3 weeks. I think it's beginning of March until June 10th. So right before the school year gets out, we're doing tutoring sessions for children who are ages 6 to 9, basically first to third grade, in 9 different locations around the county. So if you think that your child or somebody that you know would be interested in getting sort of directed tutoring that would try and help them with classwork, if they're having challenges in English, language arts, STEAM, those are perfect topics to sign up for. And if you want to do it, you can go to pgparks.com, and then sort of if you scroll down in the middle part of the page, if you haven't signed up for the Parks Direct, where we have a lot of the programs, that's where you would find it. And then you can just search for enrichment, and then it'll pull up a box that'll have the Enrichment Academy with the 9 different locations, and you can sign up for that there. No charge. So it's a program that we're trying to do with the county council, and we hope that it'll be beneficial to the county children.
Thank you, Commissioner, for catching that. This is an excellent pilot program. Looking forward to seeing how it goes, and I imagine it will be successful, and I imagine we'll be looking to expand it in all sorts of ways. So, but thanks for bringing this to our attention. So now we'll go to executive session. Pursuant to the Maryland General Provisions article of the Annotated Code of Maryland, Section 3-305B7, a closed session is proposed to consult with counsel for legal advice concerning certain provisions in a proposed memorandum of agreement with the Maryland Stadium Authority, and subsection 3-305B3 to discuss acquisition of real property for a public purpose and matters related thereto, and for the purpose of protecting the commission's negotiating position. I would look for a motion to go into executive session pursuant to that statement.
So moved,
Motion to
Mr.
go.
Chairman.
Second.
Got a motion by Commissioner Washington, a second by Vice Chair Bailey. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington,
I vote aye.
Vice Chair Bailey,
Vote aye.
Commissioner Giraldo,
I vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. I will see you all in executive session. And to the public, we probably will be in executive session for close to an hour. It could be sooner, but I would expect around 11:30 or so. All right, see you all in closed session. Good morning, everybody from the public. We have just concluded our closed session. We're gathering and we'll be starting up in just a minute or two. Okay, I think we are all back, Commissioner Washington. Do we have you? Indeed. Okay, we are all here.
Yeah. Mhm.
We have our senior counsel, Ms. Coleman. Yes, she is. Thank you. A couple things. First of all, I want to announce that direction in closed session and direction was given to staff and advice was received from legal counsel of the planning board. That's why we're in closed session and we're back now in open session. Also, there's an administrative item that I want to take up. Item 4F had been removed from the consent agenda. I would look for a motion, commissioners, to add item 4F back to the consent agenda. We're adding it back because of the timely nature of the MOU that is being.
So moved, Mr. Chairman.
Second.
Thank you. We've got a motion by Commissioner Washington, a second by Commissioner Giraldo. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
I vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
But
I vote aye as well. The ayes have it 5-0. So item 4F is back on the consent agenda. Two things. One is, again, we took it off. We put it back on because of the timely nature of the MOU that's being considered. The other thing is, as part of the consent agenda and associated with item 4F, direction to staff is the understanding is that there may need to be some work that puts this in final form, and we understand that. So with that, is there anyone who wishes to oppose the staff's recommendation on items 4A, B, D, E, and F, which are the items of the consent agenda? And is there any board member who wishes to discuss any of these items separately? If not, I would look for a motion to approve the consent agenda.
After consideration of the record for item numbers 4A, B, and D through F, I move adoption of the staff findings and approval of the items on the consent agenda in accordance with the recommendations of staff.
Second.
Got a motion by Commissioner Washington, a second by Vice Chair Bailey. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
Vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
But
Commissioner Giraldo.
I vote aye.
I vote aye as well. The ayes have it 5-0. We'll now go to our regular agenda items. We have two items on our agenda. We may be pulling the second item. Item 5, preliminary plan of subdivision 4-22034 Discovery District. We have Mr. Eddie Diaz Campbell, who will give the staff presentation. We have Mr. Taub, who is the attorney representing the applicant. I believe the City of College Park is here as well and would likely be speaking. And this is an exciting and a big project, and we're looking forward to the presentation. Mr. Diaz Campbell, take it away. Hey, before we do that, hold on one sec. Commissioners, we've been going for about 2 hours. Would it be helpful to take a 10-minute bio break? Yes? Okay, we're going to do that. Okay?
Yep.
So it's 5 of 12. We will come back at 5 after 12. Mr. Diaz Campbell and others, apologies, but we'll be back from a short recess at 5 after 12. We have our commissioners back with us from recess. Mr. Hunt, your team is here as well. We have Mr. Taub, you're on the line.
I am, Mr. Chairman. Thank you very much.
Thank you. And the members of your team, City of College Park, I assume, is here looking at the list, so we are good to go. We're back from recess. We are still on item 5, preliminary plan of subdivision 4-22034 Discovery District. We will hear from staff for a presentation, then we'll turn it to the applicant. We have some folks signed up to speak, mostly from the City of College Park and some from the University of Maryland as well. Looking forward to hearing from folks. But let's start with staff. And Mr. Diaz-Campbell, take it away. We can't hear you. You're muted.
Good afternoon, Mr. Chairman, members of the board. For the record, I am Eddie Diaz-Campbell, Planner 2 with the subdivision section. Item number 5 on the agenda is the preliminary plan of subdivision for Discovery District 4-22034. The subject project proposes 9 parcels for development of 285 multifamily dwelling units and 524,000 square feet of commercial development, in addition to the existing University of Maryland buildings that are to remain on site. The preliminary plan of subdivision is subject to approved certificate of adequacy ADQ-2022-013. As a matter of housekeeping, there are 3 items of additional backup for this case, including an exhibit with the applicant's requested revisions to the recommended conditions of approval, a memo from the City of College Park giving their recommendation on the project, and a staff memo responding to the city recommendation. Next slide, please. The site is located in the northwestern part of Prince George's County within Planning Area 66 and Council District 3. Next slide, please. More specifically, the site is located in the southeast quadrant of the intersection of US 1 and Campus Drive. Next slide, please. The zoning map shows that the site is in the edge area of the Local Transit-Oriented, or LTOE zone. The University of Maryland main campus, located west of the site across US 1, is in the rural residential zone. The wooded Paint Branch Stream Valley east of the site across Campus Drive is in the reserved open space zone. Additional university grounds south of the site are in the LTOE zone, while neighborhoods within the Old Town College Park Historic District south of the site are in the residential single-family 65 and residential multifamily 20 zones. The hotel at the University of Maryland, which is surrounded on 3 sides by the subject site, is in the edge area of the regional transit-oriented low-intensity zone. Next slide, please. The property zoning notwithstanding, this preliminary plan of subdivision was accepted for review under the prior zoning ordinance and subdivision regulations, which were effective prior to April 1st, 2022. Under the prior zoning ordinance, the site was in the mixed-use infill, or MUI zone. This preliminary plan of subdivision is evaluated according to the standards of that zone. Next slide, please. The overlay map shows that the property is within Aviation Policy Area 6, associated with the nearby College Park Airport. Conformance to the APA 6 standards is discussed in finding 3 of the technical staff report. Next slide, please. Under the prior zoning, the property was also in the Development District Overlay, or DDO zone, associated with the 2010 approved Central US 1 Corridor Sector Plan and Sectional Map Amendment. This preliminary plan is evaluated according to the standards of the DDO and will be further evaluated at the time of detailed site plan. Next slide, please. The aerial photograph shows the current layout of the site. All existing university buildings on the site are to remain, including Fraternity Row, the Leonard Town Student Housing Area, Ritchie Coliseum, the UMD Central Heating Plant, and others. These are generally located in the southern portion of the site. The northern portion of the site contains existing parking lots, which will be the site of the new proposed development. Next slide, please. This photo shows another view of the site from an aerial perspective. Next slide, please. The site map shows that the site is generally flat and covered by impervious surfaces, with the exception of Fraternity Row's open lawn. There are no specimen tree removals or impacts to regulated environmental features proposed with this application, and no Type 1 tree conservation plan was required. The site is exempt from the Woodland Conservation Ordinance because the project is subject to the Maryland Forest Conservation Act and will be reviewed by the Maryland Department of Natural Resources. There is a known issue with subsurface soil contamination on the northern portion of the site. However, this will be reviewed by the U.S. Environmental Protection Agency, as described in finding 10 of the technical staff report. A geotechnical report will be required prior to acceptance of a detailed site plan. The City of College Park has requested the applicant provide evidence of compliance with EPA requirements to them, which may be done under a separate agreement with the applicant. Next slide, please. The master plan right-of-way map shows that the site is adjacent to US 1, a master plan major collector road, and Campus Drive, a master plan collector road. This preliminary plan is required to demonstrate adequate right-of-way dedication to Campus Drive. Along US 1, the university and the State Highway Administration have a working relationship where SHA controls the travel lanes and the university controls the sidewalks. Therefore, SHA may not accept full dedication of the US 1 right-of-way, which would include the sidewalks. As a condition of approval, staff is recommending that the full right-of-way width be dedicated on the subject site side of the US 1 center line, unless declined by SHA. Division correspondence. If the right-of-way is declined, staff is also recommending a public use easement be recorded over the existing frontage sidewalk. Next slide, please. The preliminary plan shows 9 parcels outlined in red. Streets are shown in blue, with public rights-of-way in dark blue, private rights-of-way in a mid-tone, and existing university streets to remain in light blue. Parcels 1 to 3 are proposed for new commercial development, while parcel 4 is proposed for new residential development. Parcels 5 to 7 are proposed for the existing university buildings to remain. Parcel B is proposed to contain the existing private roadways of Testudo Way, Diamondback Drive, and Hotel Drive, which are currently contained in an access and utility easement established at the time the hotel was developed. Parcel A is proposed for an extension of Testudo Way to Campus Drive. Though not shown on the preliminary plan, staff is recommending that at the time of detailed site plan, an extension of Hotel Drive should be considered as well. At the time the hotel was developed, Diamondback Drive was established in such a way that it had a right-in, right-out access to Campus Drive. With this preliminary plan, that existing access is proposed to be closed, and a new full movement access is proposed to be built at the east end of the extension of Testudo Way. Construction of the new access needs to be done prior to or concurrent with the closure of the old access, in order to ensure the subject property and the hotel retain access to Campus Drive. Staff is recommending condition 18 to ensure the recommending condition 13 to ensure the access is maintained. In addition, there is an existing declaration of covenants recorded in the Prince George's County Land Records, which provides for access using and maintenance of the private streets. And the applicant is proposing to amend this covenant to include the proposed new development. Including the new development in this covenant will mean a business owners association is not needed for the property. Staff is recommending a revised condition 12 to ensure the proper covenants are in place. I'll read the recommended language for condition 12 and 13 into the record at the conclusion of this presentation. The applicant's traffic study recommends a new traffic signal be installed at the intersection of Testudo Way and Campus Drive when that intersection is provided. The study determined that, from a site operations standpoint, the intersection will function much better with a signal, and it also included a warrant study saying that a signal is warranted. However, the approved certificate of adequacy for this case found that a signal was not needed to meet transportation adequacy requirements. For that reason, while staff does recommend the applicant pursue signalization with SHA, staff has not recommended a condition to this effect. SHA will have ultimate jurisdiction over whether a signal should be provided. With this application, the applicant requested a variation from the subdivision regulations to omit the requirement to provide public utility easements along both the public and private road frontages. Staff is recommending approval of this variation request, as discussed in finding 8 of the staff report. As previously noted, the preliminary plan is subject to approved certificate of adequacy ADQ-2022-013. Staff is, however, anticipating that the applicant will apply for a revised certificate in order to propose phasing of transportation improvements and revised off-site bicycle and pedestrian facilities recommended by the City of College Park. Staff will evaluate this application to ensure it meets the requirements of the subdivision regulations once it is received. Outside of the certificate of adequacy requirements, staff is recommending via condition 10 that at the time of detailed site plan, a pedestrian and bikeway facilities plan be provided. The DDO also requires a circulation plan showing proposed pedestrian and bicycle facilities, transit service, impacted roadways, and intersections. Staff finds that further conditions requiring pedestrian and vehicular circulation plans are therefore unnecessary. Next slide, please. This slide shows the existing cross sections for Testudo Way, Diamondback Drive, and Hotel Drive. Travel lanes are shown in gray, parking lanes in yellow, sidewalks in red, and landscaping in green. The streets were improved to the standards of the DDO with the development of the hotel. Staff is recommending that at the time of DSP, we demonstrate that the 3 private streets will meet the standards specified in these cross sections. This will ensure that the streets remain in conformance to the DDO standards and that extensions of the roads will be built to the same standards. The applicant may, however, apply for a departure from the DDO standards at the time of detailed site plan. The applicant requested a modification to recommended condition 8 to allow for the possibility of a departure if one is needed. And in response, staff is recommending some revised language for the condition, which I will read into the record at the conclusion of this presentation. Next slide, please. This final slide shows the proposed route of the purple line through the property. The proposed new development on parcels 1 to 4 is not adjacent to the purple line. Staff has not received any information on the final right-of-way for the purple line, and right-of-way dedication for the purple line is not required with this preliminary plan. If right-of-way or an easement for the purple line have not already been acquired, the purple line will be able to acquire these in the future outside the subdivision approval process at any time, because conveyances of land to governmental agencies for public use are exempt from the requirement to file a preliminary plan or final plat. If at the time the subject subdivision is platted, the right-of-way or easement is already in place, the plats will be required to show it. This does not, however, need to be specifically conditioned. Next slide, please. In conclusion, subdivision staff recommends that the planning board adopt the findings on approved preliminary plan of subdivision 4-22034 Discovery District, as well as a variation from section 24-128B12 and 24-122A, subject to the conditions contained in the staff report. In addition, staff recommends conditions 1, C, and D, 19, and 20 contained in staff's Exhibit 1, a memo responding to the City of College Park's recommendation on this preliminary plan. Staff is no longer recommending condition 18 in this exhibit, as it would be replaced by new language for condition 13. The applicant communicated proposed revisions to the conditions of approval recommended by staff, which are included on the record in applicant's Exhibit 1. Staff is in agreement with the applicant's proposed revisions to conditions 3, 4, and 11 in this exhibit. Staff and the applicant have also agreed to additional revisions to conditions 1C, 8, 12, and 13, and a new condition 1E. I'll read the revised language for these conditions into the record now. Condition 1 already reads, prior to signature approval of the preliminary plan of subdivision, the plan shall be revised as follows. Subitem C should read, label the plan drawing to indicate that Diamondback Drive, north of Testudo Way, and the intersection of Diamondback Drive and Campus Drive are to be removed prior to or concurrently with the completion of construction of the intersection of Testudo Way and Campus Drive. Subitem E should read, remove the labeling identifying the private road parcels are to be conveyed to a business owners association. Condition 8 should read, the internal private roadways of Testudo Way, Diamondback Drive, and Hotel Drive shall be designed in accordance with the cross sections and specifications shown on the approved preliminary plan of subdivision 4-22034 and shall be shown on the applicable site plan submission unless a modification to the sector plan development standards is requested at the time of detailed site plan. Condition 12 should read, prior to approval of a final plat, the applicant and the applicant's heirs, successors, and/or assignees shall provide a draft covenant that ensures perpetual vehicular and pedestrian access for the subdivision parcels and maintenance for the private road parcels for the review and approval of the Maryland National Capital Park and Plan Commission subdivision section. The covenant document shall set forth the rights, responsibilities, and liabilities of the parties, and shall include the rights of MNC PPC. The covenant may be an amendment to the existing declaration recorded among the land records of Prince George County, Maryland, at Library 37039, Folio 009. The new or amended covenant shall be recorded in land records, and the book page shall be indicated on the final plat prior to recordation. Condition 13 should read, prior to approval of any building permit which proposes removal of the existing access provided by Diamondback Drive, north of Testudo Way, and the intersection of Diamondback Drive and Campus Drive, evidence shall be provided that construction of the intersection of Testudo Way with Campus Drive is either complete or will be completed concurrently with the removal of the existing access, and that said intersection shall be accessible from and to the subject property and adjoining hotel property. The existing access and utility easement recorded in Library 37039, Folio 9, shall be modified to remove the provision of the former access location and provide access to Campus Drive via Testudo Way. This requirement shall be noted on the final plat. To summarize, staff recommends the board adopt the findings and approve preliminary plan of session 4-22034 and a variation from section 24-128B12 and 24-122A, subject to the conditions contained in the staff report and the conditions contained in staff's exhibit 1, with the deletion of condition 18 and with the addition of condition 1E as read into the record by staff, and with the modifications contained in applicant's exhibit 1.
I'm sorry, Mr. Diaz-Campbell, let's slow it down just a little bit, make sure I got all this.
All
So
right.
staff exhibit number 1, you're in all the sub-conditions with the exception of number 18, and then delete number 18, and you said one other following that I couldn't hear, I didn't hear.
So the deletion of condition 18 and the addition of condition 1E as read into the record by staff.
Got it, okay.
And then continuing with the modifications contained in applicant's exhibit 1 for conditions 3, 4, and 11, and with the modifications read into the record by staff for conditions 1C, 8, 12, and 13. That
1C,
concludes
8, 12, and 13.
Yep.
Yes. And that concludes staff's presentation.
Excellent job, Mr. Diaz-Campbell.
Thank you.
Questions for Mr. Diaz-Campbell before we hear from the applicant?
Yeah, before we jump over, Mr. Diaz-Campbell, can you talk about the recreational facilities that are supposed to be on site? Because I'm wondering why we're not taking advantage of potentially seeing if we can add additional trails in the area or something, because they're utilized quite frequently by the people right there, and we've got the trail system just northeast of that, literally across the street on Campus Drive from this place.
So the applicant is proposing on-site private recreation facilities to meet the requirements of mandatory parkland dedication. These include several facilities on the inside of each building. The applicant would probably be better able to describe the exact facilities he's proposed than I can. In terms of trails, there aren't any master plan trails located on the site. The city has recommended some off-site trail improvements that can be considered through BPIS, and we are anticipating that the applicant will be submitting a revised certificate of adequacy to propose those.
Okay, yeah, we can wait for the applicant to talk about those. That's what I was kind of waiting to hear. Because if you're going to get proximity to like impact and stuff, it's literally across the street from a bunch of trails. So I think it's important that we don't just sign off on just all on-site private recreational facilities when there's going to be a big impact to the public facilities right around there that the residents of the site are going to be utilizing. And if we can get them to make improvements so everyone including their residence benefits, and that would be great.
Thank you, Commissioner. Any other questions for staff before we turn to the applicant? All right, Mr. Taub, floor is yours. You may want to introduce the members of your team and take it away.
I will do so. Thank you, Mr. Chairman, members of the planning board. Good morning. I'm sorry, I guess good afternoon. And it really is a great pleasure for me to be here this afternoon representing Brandywine Realty Trust. This is, as I believe you all know, a very exciting project that is going to be really have a major impact on both the city of College Park and the University of Maryland. With us today, I will say we have the following people. We have Mr. Carlo Colella, who's Vice President of Administration and Chief Administrative Officer for the University of Maryland. We have Mr. Ed McGinnis, who is the Assistant Vice President for Real Estate at the University of Maryland. We have Ms. Tracy Skinner, who's Counsel at the University of Maryland. We have Mr. John Norgent, who is Senior Vice President and Managing Director of Brandywine Realty Trust. We have Mr. Marco Greenberg, who is the Project Manager for Brandywine Realty Trust on this project. We have Mr. David Bickle, who is with the firm of Soltes, who's our land planner on this project. And we have Mr. Wes Guckert, who is our transportation planner on this project. We are very pleased to have all these people with us today. I would like to, at this point, ask, I believe Mr. Colello would like to say a few words with regard to the project and its impact on the University of Maryland. So I will ask Mr. Colello if he'd like to speak at this point.
Thank you, Mr. Colella. Good to see you. Take it away.
Thank you, Mr. Taub. Good afternoon, Mr. Chair, members of the board. Again, my name is Carlo Colella, and I'm offering this very brief testimony wearing two hats, one in my capacity on behalf of the University of Maryland and the other on behalf of the Terrapin Development Company. In my role as Vice President and Chief Administrative Officer here at the university, my portfolio includes, among other areas, real estate activities. In my role as the Terrapin Development Company board member, I am here very proud to be part of that group. Of course, I think most people know the Terrapin Development Company, or TDC, is a joint venture real estate and economic development entity created by the university and its affiliated University of Maryland College Park Foundation. Both the university and TDC strongly support this project, which we see as a catalyst to further the shared goals in our region for economic growth, job creation, new company startups, and the creation of vibrant and dynamic communities in which people will work, live, and play. Universities, of course, are at the heart of technological and scientific innovation. Solving today's grand challenges requires innovation and forward thinking from young professionals, both on campus and in surrounding communities where faculty, staff, and students work with private sector companies, startups, and innovators. A recent report from the University of Maryland, which produces thousands of science and tech graduates each year, indicated that 74% of University of Maryland graduates are employed in the DC metropolitan area post-graduation. The burgeoning development of the Discovery District, the area adjacent to the main campus, physically located just east of US 1 Baltimore Avenue and encompassing the area around the College Park Metro, encourages students, graduates, and other young professionals to work in College Park. The project in front of you is a signature development directly across the street from our state-of-the-art computer science building, which will physically link the University of Maryland main campus to this Discovery District. Referred to as Discovery Point, the $300 million mixed-use development will combine innovation, business, and community plans to deliver over 500,000 square feet of Class A workspace for small businesses, corporations, and startups in research, life sciences, tech, and financial sectors. It will also include retail spaces and between 200 and 250 multifamily units to create a blended living and working experience for young professionals. This development continues our work with local and regional partners to create great neighborhoods, of vibrant spaces to live, work, and play. So on behalf of both the university and the Terrapin Development Company, I want to offer our strong support for this project and thank you for your consideration.
Thank you, Mr. Colella.
Thank you, Mr. Colella. If I could, Mr. Chairman, if I could now call on Mr. John Norgin to say a few words with regard to Brandywine Realty Trust and their involvement in this project as well.
Great. Thank you, Larry, and thank you, Carlo, for your remarks and your support. Shapiro and the commissioners for your time and consideration this afternoon. For the record, my name is John Norgin, and I am Senior Vice President and Managing Director for Brandywine Realty Trust, the developer of this project. Brandywine was very excited to have been included in what turned out to be a very competitive process, and we were thrilled to be selected by the University of Maryland and Terrapin Development as their development partner for this project. Brandywine is highly qualified to take on this role. We've developed over 12 million square feet of prime office and mixed-use space. We've very successfully worked with other prestigious universities. Our Discovery District Discovery Point project, it fits very well with the mixed-use, multi-phase, urbanized projects that we've been focusing on. And this project, this new place that we're creating, will be a tremendous addition to the landscape along Baltimore Avenue and College Park for all the reasons that Carlo mentioned in his remarks. If I could offer just a few highlights about Brandywine, we are a publicly traded investment grade real estate investment trust, or REIT, headquartered in Philadelphia with operating in 3 primary markets. Philadelphia, of course, metropolitan Washington, D.C., and Austin, Texas. We own and operate over 23 million square feet of space, and we've built over half of that ourselves. We've won many accolades. One we're particularly proud of is we were named by Forbes magazine as one of the most trustworthy companies based on our corporate governance policies and our overall transparency. We are also at the forefront of the environmental, social, and governance, or ESG movement, and we have ESG ratings and scores that are well above the industry averages. Brandywine builds and owns for the long term, and we really strive to become an integral part of the communities we serve. We're very good at working with elected leaders and community groups to execute on a shared vision that includes both our first-class development and community engagement. Our president and CEO, Jerry Sweeney, has been in that role since the company was founded almost 30 years ago. And he leads an executive team that also has a lot of stability and longevity. Jerry has instilled a tremendous company culture in Brandywine that includes a set of development values that we hold dear. And these include a focus on placemaking and green space, on community, sustainability, a prioritization of people, not buildings, connectivity and walkability, and last but not least, innovative architecture. And we're incorporating each and every one of these development values, these elements, in our Discovery District project. So on behalf of the project team at Brandywine, I just want to say we are really excited to be a part of this project and to be working with the University of Maryland and Terrapin Development. And I want to thank you again for your time this morning. If I could take another moment and just answer Commissioner Dern's question about the recreation facilities. So I think first and foremost, we are going to have over 50,000 square feet of outdoor public space that's going to be curated for a good flow of people through the project, to the project. And it'll be landscaped to allow for collaboration. And so we're very excited about the plans that we have for the outdoor space, and we're putting a lot of focus on that. Inside the buildings, as Eddie had referenced, we're including recreational facilities, including a fitness center. We have abundant bike storage planned for those who will be cycling to the buildings, and we have a rooftop terrace as well. So there'll be, again, that combination of outdoor public curated space and indoor amenities for the tenants of the building to use.
Thank you, Mr. Norgin.
Thank you, Mr. Norgin. Appreciate that. At this point, Mr. Chairman and members of the board, I'd like to just indicate that we are in We do agree with the staff recommendation. First of all, I also want to say I want to thank Mr. Diaz-Campbell. He's been very good to work with. He's been very accessible. We've had many conversations with regard to this, and it really has worked out to be very much of a collaborative effort to get to the point that we are today. We really greatly appreciate that. We are in agreement with staff recommendation and the conditions as amended. We believe that this will produce a great project as was described. I want to point out that this is going to be a phased project, that our phase 1 will be on parcels 1 and 2, which are right at the intersection of Campus and Campus Drive and Baltimore Avenue. And there will be basically 2 buildings, one on each parcel. That will be a combination of office and retail space in both, with, as Mr. Nordgen explained, a really beautiful plaza between the 2.
Mr. Taub, hold on one sec. I'm actually curious, as you're doing this, for us to look at the graphics so we can track what you're talking about. So,
Sure.
Mr. Flanagan, if you could pull that slide up that denotes the parcels, that'd be helpful.
There we go. So you can see parcels 1 and 2 that are roughly divided there right at the intersection of Campus Drive and Baltimore Avenue. The next 2 parcels are 3 and 4. Frankly, at this point in time, parcel 3 would be additional office spaces currently proposed for that. Parcel 4 is currently proposed for residential building, multifamily residential. But frankly, we just don't know at this point in time which one will be the next phase between the 2. It will be either 3 or 4, and then obviously the other following. Obviously, it's going to be a matter of evaluating market considerations and other factors as well whenever that comes about. But we are moving forward with our detailed site plan application for parcels 1 and 2 at this point in time. And we're very excited to be working on that. We'll be back to see you about that, hopefully in a very short period of time. We do agree with the conditions as amended.
But if you can, it may not be what's before us, but while we have you, can you continue on? What is the expectations for parcels 5, 6, and 7, such as it is where we are now?
Right now, we are parcel. Let me work backwards. Parcel 7 is the university's property. There are no plans for any development. That is predominantly Fraternity Row at this point, and there are no plans for that. No plans of development. Brandywine is only looking at this point at parcels 1 through 4. Parcels 5 and 6 include, as you know, the hall for the food hall at that point, and parcel 6 is, I believe, partially it's certainly going to be the area where I believe you got up above actually parcel 7 also includes, I believe, Ritchie Coliseum and the service building for the university. Parcel 6 is also, I believe, part of the service building itself. But in any case, parcels 5, 6, and 7 are not going to be proposed for any additional development. It is, at this point in time, it is only parcels 1 through 4.
Okay, thank you for that.
Sure.
Mr. McGinnis, you joined us. Anything you want to add around that, or is that clear enough? You're on mute.
I'm off mute. Chairman Shapiro, thank you for doing an excellent job of reading body language. I want to add to what Mr. Taub said, that on parcel 7 at the site of our Leonardtown housing, we are currently working with a developer on the old Leonardtown site, and we would anticipate coming before mandatory referral for that, keeping it on university land for below market rent graduate student housing. The new Leonardtown housing will come offline sometime around the end of this decade, and that will become a development opportunity, but it's not on the board yet. But we do anticipate development at the Leonardtown site on parcel 7.
Okay, thank you for that.
As I indicated, we do concur with the conditions as amended. Believe that we've resolved a number of issues through those, and again, appreciate the cooperation of your planning staff in all respects with this. So with that, we're here to answer any questions. We have our team here and happy to do so. Thank you again for your attention. And I will, again, we're here for any questions.
Thank you, Mr. Tao. Commissioners, we, before questions, just to remind you all that we will hear from the City of College Park as well. There's nobody else signed up to speak before us beyond folks in the City of College Park. But before we get to the city, are there questions for the applicant or any members of the team or the University of Maryland Terror and Development Corporation folks? Yeah, all the folks we've heard. Questions?
Yeah, I have two questions for Mr. Taub or the applicant in general. On parcel 2, parcels 1 and 2, those are pretty important parking areas for the surrounding businesses that are operating in that hotel site. And parking is tough when you're trying to go to those businesses. So what do you envision happening? Are you going to funnel it back into the parking garage that's on like the east side of the building that's not included in the development right there? Or are you going to have on-site parking in parcels 1 and 2? Because those are really important for the street-facing kind of businesses at the moment if you're trying to get to them with a car.
Right. Commissioner Dorner, that right now, what we plan is that we believe there's going to be sufficient parking remaining on parcels 3 and 4, maybe 5, I can't recall exactly, but behind, if you will, or east of parcels 1 and 2, there will still be, if I recall correctly, over 300 parking spaces, surface parking spaces that will remain there. And there will, as you indicated, you've got the parking garage that is now attached to the hotel, but it is a public parking garage. And as you may know, and many people understand, there are very often many vacant parking spaces in that parking garage that are available for the public to park in. So I think between the two, we'll be dealing with this more specifically as we bring the detailed site plan to you. But we do believe that we want this to be, we believe the location here is such that this is a very walkable, bikeable project. We have, as you know, as was indicated, the Purple Line station is being proposed just on the south side of the hotel. I believe it's on Rossborough Drive. And with that, we are probably less than a mile, maybe a mile or so from the College Park Metro Station. We believe just a natural for a lot of walkability and bikeability, but we do believe there will still be a sufficient number of parking spaces located between the current spaces that are on site, surface spaces, and those that will be available and are available in the parking garage to accommodate those who are currently using the parking lot.
Okay, yeah, I don't disagree that the walkability and the bikeability and pedestrian traffic are great in that area and will improve the Purple Line. I would just encourage you to figure out voucher systems in that parking garage if you do it with the hotel next door, because it's not cheap. And I go up there to get pizza and other stuff around that area, and I'm not going to be wanting to be parking in that parking garage for the prices that they're charging right now. So that would lose my business and other people if that's like one of the only options that comes up. So just be careful about that, I think, as you're kind of working through the project. The other question that I had is actually on some of the BPIS additions that you've agreed to at the City of College Park. So I'll just mention one thing that I had a question about, and we can let College Park talk about what they're asking later on. But one of the improvements is on, I think it's called Norwich Road, that runs east-west over there, and it crosses over Rhode Island, and it's asking for sidewalks on the south side of that. There is a segment of probably maybe 100, 150 feet or something on the northwest side of the intersection of Norwich and Rhode Island that is incomplete sidewalk. That if you could tag into that as well would be ideal, because then you're going to have a complete sidewalk system on the north side of Norwich as you're actually going towards your property there. That's not complete right now, and I've seen kids walking on the grass and other stuff on that north side. So if you can think about that, then that would be useful as well.
Thank you, Commissioner Dorner. We have a mandatory maximum contribution for our BPIS issues here on this project of about $341,000. And the particular projects that will be directed toward which that money will be directed are those that we've agreed with the City of College Park with regard to those that they have recommended. And certainly we will take that into consideration. We're probably going to seek an amendment to the certificate of adequacy with regard to that. So we'll certainly take that into consideration as we move ahead.
Okay, yeah, because the segment is literally across the street from the trail that runs north to south, and it's going to be used by your residents if they're trying to get to that trail and they're coming through. There's like a little cut through that you can get to the south from the southeast side of your parcel if you're trying to get to this trail system and not going on Campus Drive. So I think it's a direct link to what your folks will be using down the road potentially.
Thank you.
Okay, thank you. That's it.
Thank you, Commissioner. Any commissioners, any other questions for the applicant before we turn to the City of College Park? No questions. So let's turn to the City of College Park. We have no one else signed up to speak. Ms. Shum, Ms. Ferguson, Ms. Bader. Ms. Shum, I'll turn to you. You can manage it as you see fit. And introduce yourself for the record. And good to see you. And thanks for joining us.
Thank you, Mr. Chair. Good afternoon to you and to members of the board. I do want to say that the two other folks from the City of College Park that signed up, it may not be necessary for them to speak. Certainly our city attorney wanted to, but she had to leave to testify at another public hearing. So she won't be with us today, and Ms. Bader will only speak if necessary. So
Ms. Shum, let me hold one sec. We can hear you perfectly, but we don't see you. We don't have to see you, but the camera isn't quite showing.
Oh,
there we go. Now we can see you.
Not interesting. Okay, so I was having a little camera issue earlier. Sorry about that. It showed that I was showing my face, but actually I wasn't. But there you have it.
Good to see you. Take it away.
For the record, my name is Terry Shum. I'm the planning director for the City of College Park, and I'm here today representing the City Council's position on this project. We do have a letter before you dated, let's see, it was updated. Sorry, you probably had 3 letters before you. Hopefully you just have the latest, which was dated February 14th. But we did submit the city's official position, which was a motion approved on initially approved on January 31st in your packet. And as you will note, the City Council voted unanimously to support this project. And I will say they were very excited about the project itself. Can't wait to see the detailed site plan and learn more of the details, because we all agree that this is an important project. It's significant to the city, the university, and the county. And so we look forward to seeing it come to fruition. But the City Council did recommend a few conditions. You'll note that we have conditions 1 through 7 in our letter. I will really only be addressing conditions 1 through 6, since number 7 relates to a separate agreement that the city typically obtains with a developer to address items that may not be addressed by you, the planning board, and cannot be enforced by you, the planning board. So I won't review that with you. But I just wanted to say that the city takes their proposed conditions seriously, and their support of the project is contingent on the conditions we recommend. But I'll admit that the city doesn't always get it necessarily technically correct. So our wording may not be 100% consistent with what your staff recommends. And we totally understand that, and we appreciate your staff working with us to get that right. And I believe we've done so in this particular case. But I would like to just run through a few of the city's recommended conditions so that I have clarity myself on what's currently before you today. And so I can maybe offer a little bit of explanation of why the city recommended those conditions. And I should
Ms.
also
Shum,
point,
let me interrupt for a second. In terms of a process, because there's a lot of detail here, and I think it's going to be, if you don't mind, I think it's going to be helpful if we sort of take a minute point by point as you go through them, and we may even look for feedback from the applicant, feedback from staff as you go through these point by point. Okay, is that all right with you?
oh yes, I would very much appreciate that.
Okay.
I think that would help have clarity. And I do want to mention that the applicant has agreed to all of the city's proposed conditions. So it's not like we are in disagreement at all with the applicant. And we are in significant agreement with your staff at this point. There may just be a little nuance in some of these points, which I'd like to address.
And that's what we want to flesh out, is just to make, really what I want to focus on is the points where we may still have a little bit of work to do, just so we can hear that and we can, move accordingly.
Thank you. I do appreciate that. So we will start with the city's proposed condition numbers 1A through D. So our condition 1A has been included in your staff's recommended condition. I believe it's 1C, if I got that right, Eddie. So there's no further comment needed there, if you agree.
Eddie?
Yes, sorry, that is one of the conditions we recommended to address your condition. The other one being condition 13.
Okay, and 13. So 13 was new to me today. So, but I believe that is correct. Moving on to 1B.
And hold on one sec,
Okay.
Ms. Shum. So Eddie, we're fine with that. Mr. Taub, you're good with that as well?
Yes. Oops, sorry. Yes, I am.
Okay, thank you.
Our proposed condition number 1B addresses the purple line. And there is no condition currently being recommended that addresses this. And this may be for a legal reason, which we really don't want to argue. We just maybe want to understand a little bit better, because as you could see on one of these diagrams, the proposed purple line runs through the middle of this proposed subdivision. And it runs primarily concurrent with Rossborough Lane, but it does diverge as it intersects with Campus Drive. And of course, Rossborough Lane is a private road, not dedicated right-of-way, maintained by the University of Maryland. So it may be correct, and I really could not get this information, but I'm surprised if the purple line has not figured out it's either dedicated right-of-way for this facility or the dimensions of the proposed easement. And so typically during the subdivision, you look at the dedication of right-of-way for new streets that are being created, or additional right-of-way to be dedicated from existing right-of-way. And none of that's happening in this proposed subdivision. And given that the purple line is such a huge state transportation project of, large proportion and importance, we just thought it was odd that it was not being represented more technically and more specifically on the preliminary plan. But I'm sure there's a legal explanation for this, but I just wanted to explain why the city recommended this condition.
So let's take a second on this one, because I heard Mr. Diaz-Campbell refer to not having that information yet. It hadn't been provided to staff. Is that right, Mr. Diaz-Campbell?
That's right, Mr. Chairman. For us, the reason that we don't believe, there's a few reasons that we don't think that this needed to be shown on the preliminary plan, and why we don't think the condition is needed. So we do at the preliminary plan look for dedication of master plan roadways. However, the purple line is not a master plan roadway. It's not really. And so, the requirements of our subdivision regulations only speak to it in the sense that if there is a dedication of land to a governmental agency for public use, as would be the case here, then that dedication is exempt from the requirement to file a preliminary plan of subdivision or final plat. So essentially, that means that if the Purple Line has not acquired their right of way already, they can do it at any time, regardless of what this subdivision shows. When this application comes in for a final plat, at that time, the final plat will need to reflect any right of way or easements that exist already for the Purple Line, and that would be just a requirement of the final plat, not something that needs to be conditioned. If at that time, when the plats come in, the Purple Line right of way has not been finalized, then that is something that can happen after the final plats. The plats for parcels 6 and 7, once recorded, wouldn't reflect the Purple Line dedication, but it would still be a legal subdivision once the Purple Line comes through, and there wouldn't be a requirement to have new final plats based on that. So, and we do see it as a timing issue. This the condition as the city recommended it wants the Purple Line shown on the plat for parcels 6 and 7. So if you don't have that information when parcels 6 and 7 come in for platting, then it holds up the ability to plat those parcels, and there isn't
at that time.
a legal basis. Right.
Okay. All right. Thank you for that, Ms. Shum. Clarification made sense.
It does, and I understand it's complicated and timing is everything here, but
Okay.
so it's important, I think, to have this diagram, which I think is part of the preliminary plan submission, so you can see just where the proposed alignment is, because that proposed alignment exists. It's under construction now. I guess we just can't clarify what the boundaries of this alignment are at this time. So, the city accepts that. There's nothing we can do about that.
Okay. Thank you for that. Mr. Taub, anything you want to add on that?
No, Mr. Chairman, my understanding is that this is going to be a non-exclusive easement, not a right-of-way. And I think that's a significant difference in terms of its impact on the parcels. If it's only an easement, in particular non-exclusive easement, if it's determined, if that has been set forth and we'll know exactly where it is, we will certainly establish that on the final plat. However, I'm not sure that it should have any impact on the delineation of the parcel lines at that point. But we'll have to deal with that later on. But that would be our position right now.
Okay. Thank you for that clarification. Mr. McGinnis is nodding his head. I think he is in concurrence. Okay. Thank you. Yeah. Thank you for that clarification. All right. Can we move along?
Yes, please. Let's go to 1C, which I believe is now reflected in your staff's proposed condition number 8. So I would have no further comment on that.
Sounds good.
Okay. On 1D, the same thing there. Your staff has taken this into consideration and added, I'm confused about whether it's condition number 18A, which may have gone away in lieu of condition number 13, but maybe we can get clarification on that from Eddie.
Yes, that is condition. That is condition 20A. condition 19A, excuse me. That talks
All right,
about
I
the
was
extended hotel drive.
Okay, thank you. So it is being addressed. If we move on to condition number 2, this one is a little bit more complicated for the city, I believe, and I thought that your staff was recommending today a condition to address this, but I don't know that I heard it. So let me just explain. So we're asking that when the new intersection is created at Campus Drive and Estudo Way, that it be a signalized intersection. And really our reasoning is based on the applicant's traffic impact study that was submitted. So it says on page 25 that that intersection as a full movement intersection, that means left turns and right turns, as the applicant is proposing, would fail with delays of over 200 seconds for all movements. And as a result of that, a signal warrant analysis was prepared, and that analysis meets all 3 of the warrants for installing a traffic signal. So if you recall, when it used to be called Paint Branch Parkway, now Campus Drive, was first built as a county road, it was a limited access roadway. So there were no turns at all allowed from any adjoining properties. So times are changing. We already have a limited access now further north, as shown on the plan, that will go away. And so when that goes away, I think this new intersection will be primary access for this property and new development. And that's recognized in the applicant's traffic study. So we would hope that there would be a condition related to this, because traffic issues are really important to the city council. And we understand the road now belongs to SHA. They will be the deciders of whether or not this happens. But we wanted to be on record saying that we believe it is very important for this to happen. And because of what's stated in the traffic impact analysis, we don't really understand why it's not part of the certificate of adequacy, which of course has already been approved, which I guess the city doesn't quite understand, because it seems like putting the cart before the horse, because we're here today addressing these issues as part of the preliminary plan approval. So anyhow, more questions than anything about this one, but if I could get clarification from Eddie, whether you're proposing a new condition to address this now?
So we are not recommending a condition for the traffic signal. To be clear, with the traffic study found that the intersection would operate adequately. It would meet the technical requirements of transportation adequacy. The traffic study did find that from a site operational standpoint, the site would function much better with a traffic signal. So that's why the applicant recommended a signal. It's also why we, the staff, would recommend that the applicant pursue signalization with SHA. But that intersection, that signal is not needed for technical adequacy, which is why it was not required with the certificate of adequacy. And the reason we're discussing it now is because the city has nevertheless requested that it be provided as something to improve traffic operations beyond the threshold of adequacy. The
Can I jump in there, Mr. Diaz-Canel? Because Ms. Shum, so my sense of this is the applicant is proposing the signalized intersection, and staff supports that. So I think, I mean, it's not a condition. I think it's what's being proposed, and we're all in agreement.
Yeah, the reason that we didn't recommend it as a condition specifically is just because if it's not needed for adequacy, we don't have the code basis to recommend it as a condition. It doesn't mean that the applicant can't doesn't mean that the applicant can't provide a signal. It doesn't mean that the applicant can't accept a condition from the city or from this board. It just means that our staff cannot recommend it.
Good afternoon.
Yeah, Mr. Chairman, thank you again, members of the board. I would agree with the statement made by Mr. Diaz-Campbell, and I would just point out that, as he said, we do meet adequacy. This traffic study indicated that we do meet adequacy with only a stop sign. We don't need the signal to meet adequacy at that location. However, that said, my client has always been saying very consistently that it would like to put the signal in at that location. And whether we meet the signal warrant study or not, it still depends upon the recommendation on the allowance, frankly, by the State Highway Administration. We just have no ability to put that in without, they are the operating agency for Campus Drive at that location, and we will need their approval before doing so. If they choose not to approve it, then it can't be done. But otherwise, I just want to be very clear that the signal is not required for adequacy.
Thank you. And somebody else was jumping in. I missed who it was. No? Okay. All right. We're fine. Ms. Shum, good enough?
Well, the determination of adequacy is a little confusing to the city because when we read the study, we read that it doesn't meet adequacy. It fails when you consider all traffic and when you consider that it will be a full movement intersection. So for that reason, we believe it is an adequacy issue, but your certificate of adequacy has already been approved. There will be an amendment coming from the applicant regarding that, and perhaps the city needs to chime in on that as well. But regardless, the applicant has agreed, if SHA agrees, to provide the signal, and therefore we could shift this to our separate agreement with the applicant. If
that'd be great.
If that makes more sense.
That does make more sense.
Mr. Chairman, if I could, just if it's helpful, we have our traffic consultant, Mr. Guckert, here this afternoon to address it and to really sort of clarify that point, if you would like.
Well,
I do, but I don't want to get into back and forth around the how adequacy was determined, because that's actually, oddly, that's not what's really before us. Now, in terms of the process around the certificate of adequacy and helping Ms. Shum understand that, maybe Mr. Guckert, or maybe somebody from our transportation, one of our transportation experts from our staff could explain that process as well.
For the record, this is Glenn Burton with the transportation section. I had the privilege of reviewing the traffic study, and I prepared a referral accordingly as part of the adequacy test. Mr. Diaz-Campbell was correct. The procedures outlined in the transportation review guidelines clearly states that it is not necessary for this applicant to undertake a signal warrant study based on certain numerical thresholds that have been met in the analyses. Where we are today is if the applicant or a private citizen for that matter wants to have a traffic signal installed anywhere, they could go directly to the State Highway Administration and request permission to have a traffic light installed. The planning board does not have to weigh in on that decision. So if Mr. Taub or the applicant insists that they want to have a light there, they could go directly to the state and says, I would like a permit to put a light here. And then it becomes a private agreement between the state and that applicant who wants to pursue a light. But at this point in time, there's no reason why the planning board needs to be part of that agreement.
Thank you for that. Thank you, Mr. Burton. Much appreciated. Mr. Gucker, anything while you're on, anything you want to add to that?
No, I think Glenn did a great job as usual. Clearly, Mr. Chairman, if you want further explanation, I'm here to do that at your pleasure.
Thank you. All right, Ms. Shum, I think we're pretty clear with this. I think, some memorializing this in some way between you and the developer seems like the appropriate way to go.
Okay, thank you for the discussion over this. Moving on to proposed condition number 3. That's fine. The city can remove this from our request and include it in our separate agreement with the state of Maryland, because we would like to see some kind of written evidence that environmentally this site has been cleared for development. So if you can't include it, then we'll circle back around and we'll get it another way.
Thank you.
Proposed condition number 4 is really not needed because that's part of the rules and regulations of the county at any rate. So we're fine with that not being included. And number 5, same thing. I think it would happen as a matter of course, given the adjacency of the project to the local historic district. So that brings us to our last condition, which is number 6, and we have proposed A through E. First one up is A, and we've talked a little bit about this already. This relates to the requirement for bicycle and pedestrian facilities up to a certain cost cap. So the city has recommended proposed projects that are completely different from what the applicant recommended initially and what your staff concluded. And the applicant, however, has agreed to a set of alternate improvements, which the city prefers and which the university has agreed to. And it looks like our only way to address this now, since the certificate of adequacy has been approved, is for the either the city or the applicant to request an amendment of that certificate to include the improvements that the city prefers. We reviewed what the applicant proposed. We didn't find them feasible at all. Some of them had already been done. Some of them were just just not well, most of them have been done already. And so if the applicant is going to be required to make improvements, they need to be realistic. So the city provided comments during SDRC and at other times to indicate our preferences, but somehow they didn't find their way into the certificate of adequacy. So as long as there is a way to address that at this, by amending the certificate, then so be it.
Thank you. So there's a bit of a process question here. Maybe Mr. Burton, Mr. Diaz-Campbell, Mr. Taub, you may want to weigh in as well around this process question.
I guess I'll begin. Mr. Chairman, it's my understanding this is
Ms.
all.
Taub, before you, Ms. Taub, let me interrupt a sec because we have Director Checkley here and she's suggesting that staff weigh in on this as well.
Yes, so in terms of process.
So the issue is, Mr. Diaz-Campbell, is less around the process and more about why you did not recommend these specific improvements.
The specific improvements recommended by the city?
Right. So you took a different position than the city. Forget about the process for a second. Director Checkley is suggesting it might be helpful to have you all weigh in on why these were not the improvements that you recommended.
So for every BPIS application, there is a limited cost cap, and we have many sources for potential ways to use that money. We have what the applicant provides in their BPIS study. We have recommendations made by operating agencies such as DPWT and SHA. And of course, for this case, we have recommendations made by the city. So during the review of that BPIS and the formulation of the certificate of adequacy, our staff do have to prioritize those improvements, and that is done essentially according to which meet the criteria for use of BPIS funds, which is that there needs to be a nexus between the proposed improvement and the subject site. That means that the off-site improvements will directly benefit the residents and visitors to this site specifically. So not necessarily what's just generally needed in the area, but what will improve access for this site specifically, because it is an adequacy requirement. So one thing, so when the result of that analysis was that our staff prioritized the improvements in the BPIS and improvements recommended by DPW&T. Now, after we had already made that recommendation, we had further conversation with the city, and found out that some of the improvements recommended in the BPIS were already done. So, if we had known that information from the beginning, perhaps there would have been a cause for a different prioritization. But at this point, really the best way to correct that is through a revised certificate of adequacy, which is something that can occur after this preliminary plan is approved.
Okay. Thank you for that explanation. Mr. Taub, you were going to weigh in as well?
Thank you, Mr. Chairman. Just to indicate that this is obviously a new process and something I think everybody's sort of finding our way through this. But the reality is that, as Mr. Diaz-Campbell indicated previously, we are likely to be going in to seek an amended certificate of adequacy through the detailed site plan process for this and other reasons. This did not indicate the phasing of the process as I described before, and there's some other issues. But my understanding from the staff is that it can be amended without going back to the planning board to seek a revision or any other action with regard to the preliminary plan. We just work with the staff with regard to that, and we intend to do that. So we'll work this out as we move forward.
Thank you. So, Ms. Shum, if you're hearing, as I'm hearing this and you're hearing it too, it doesn't sound ideal, but it sounds like folks are basically aligned with where you are, and there is a process to address your issues. That's what I'm hearing. You're on mute, Ms. Shum.
Oh, there was a ghost who muted me. So yeah, the city would just say we would really appreciate engagement early on with the county transportation staff on the adequacy issues, review of the traffic study, and particularly the BPIS, because we've done numerous studies here. We have projects that are on the shelf, if you will, that have already supported locally, and that could be used to fulfill this requirement. And we did provide a copy of the study we were using to support our recommendations to county staff at the time of the SDRC. But, you know, for whatever reason, it didn't get considered, but we do have a way to correct it. And so I appreciate that and look forward to addressing you when the amendment comes forward. Or I guess that would be the planning director, because that would go to the planning director.
It's going to happen at the staff level, right? And your criticism is noted. I'm sure the staff is taking that into, you know, that they hear it as well. And that, you know, we all can do a little bit better at times. So, you know, so noted.
Thank you. And I think I'm wrapping
okay.
up.
Is that
Sorry.
it?
No, I'm just, but I am wrapping up. So if we go to, we're still on condition number 6. I believe we're on 6B. And that simply asks that at the time of detailed site plan, a pedestrian and vehicular circulation plan be provided with the application. And so to my knowledge, this has not been incorporated in your staff's recommendation. It was mentioned that perhaps condition number 10 does this. In fact, it includes bicycle and pedestrian facilities to be included, but does not address the actual circulation that needs to occur on site. And especially given the proposed phasing of the property and the possibility of roadway, you know, easements changing, this and based on the comment I heard earlier about access to parking, I think that this is really important. It's been provided with DSPs in the past, so I'm a little surprised not to see it included in your staff's recommendation.
Ms. Diaz-Canel, any comments or thoughts or reactions to that?
Yes, so the bicycle and pedestrian facilities plan would certainly also show bicycle and pedestrian circulation so that you can see how people are using those facilities. For instance, you would show on a bicycle and pedestrian facilities plan sidewalks and bike lanes, which are, you know, linear routes. In addition, the DDO requirements require a plan that shows bicycle facilities, transit service, pedestrian facilities, the roadways that are impacted, intersections that have to be provided. You know, that sort of plan would show vehicular circulation. So, you know, we just did not find it necessary to add this condition because it will be required.
Okay, so the short of it is, Ms. Shum, even though the language doesn't reflect it, the assumption is it's a given that it'll be included.
If it's a given, then that's great. I heard Mr. Diaz-Campbell refer to BPIS a lot, which of course is off-site, and our recommendation refers to on-site. How will people get from the proposed parking to the front door of the new office building? How are cars expected to traverse the site? And so these are things that are really important to look at the time of detailed site plan. And if you require it already, great. If not, we'd like to see it as part of the application.
I think it's, I mean, clear as day, at least in my experience, that is required.
Yeah,
I've never seen that not come before us.
Yeah, my understanding is that Mr. Diaz-Campbell said yes, that'll be in the DSP.
Yes.
Okay, great. And with that, that concludes the city's comments. Thank you.
Thank you. I appreciate all your work on this and going through the details, and it sounds like we're aligned enough. That's what I'm hearing.
Just one question for Ms. Shum.
Yes.
When you're looking at the sidewalk improvements, going back to my earlier question about Norridge Road, when you're iterating on that with staff and with the applicant, just that at the intersection of Norwich and Rhode Island, if you can consider the northwestern side, I don't think that improvement has been made. And there's a section, a very small section before you get to the parking lot of a multifamily building right there that doesn't have a sidewalk that would connect people to the trail right across the street from it. So if you could consider that, I think that's, to me, in my view, more pertinent to that site and access on and off that site than doing the south side of Norwich, going back to the playground and other stuff that basically leads to almost nowhere. I'd rather get people to and from the trail better before we focus on the south side sidewalk going really far back to an area that's not connected to Campus Drive or anything at the moment.
I do appreciate those comments, and I'm familiar with everything you mentioned. And I think some of that might relate to the proposed redevelopment of Old Littertown that I believe is in the planning stages at the university. And you know, depending on what they're proposing at that location, certainly sidewalk connections need to be included as part of that.
Okay.
And what happens to the
McGinnis?
remnant of Rossborough Lane as it goes back to Rhode Island Avenue is also an issue, and I think will be addressed as part of the Leonardtown redevelopment.
Okay, perfect. Thank you.
And so, Mr. McGinnis, Mr. Colella, you've heard Mr. Commissioner Dorner's concerns and direction.
The short answer is not only we heard them, but we share them entirely. We are actually generally, even as part of the Leonardtown project, working on creating connectivity, because we're talking about the development in the Discovery District. The balance of the Discovery District is on the east side of the CSX tracks. So we're giving a great deal of thought to creating connectivity, bicycle and pedestrian connectivity, to make the whole thing work. So we mentioned, for example, the trail on the north side of Campus Drive. That is something that the city and the university, through the College Park City University Partnership, are already partially funded and working on design of. I know I disappointed Ms. Shum because one of the DPIS suggestions that she had was this Norwich Road side path. The universities are actually already designing and funding that. So we're there, we're ahead of it, but it's in all of our collective best interest to have this connectivity to this superior trail network, to the metro station, and for the university's perspective, the entire Discovery District in its whole.
That's great to hear.
And if I could just add, also share this mutual interest, and since there is such familiarity among some, I also mentioned that we, the university, is making a connection from Columbia Road or Columbia Drive to Campus Drive itself, around the property that we refer to as the Paint Branch building. Most people will know as headquarters of IonQ. So that's just another piece of infrastructure to better connect and make more walkable and bikeable, you know, from west to east to the College Park Metro.
Excellent. Great. Thank you both, gentlemen. Okay, so commissioners, there's nobody else signed up to speak on this. So let's move to deliberation. Commissioners, any further questions or thoughts or reactions that you have? Anything we need to talk about? Any other anyone else we need to hear from? No? Okay. So given that, I would turn to you, and what is your pleasure on this item?
Mr. Chairman, I move that we adopt the findings of staff and approve preliminary plan 4-22034, variation from section 24-128B12 and variation from section 24-122A, along with the conditions as outlined in staff's report, and as further modified by applicant exhibit number 1. I move that we approve all subconditions outlined in staff exhibit 1, with the exception of number 18, that we add new subcondition 1E as read into the record by staff, and conditions as further modified by applicant exhibit number 1 to include conditions 3, 4, and 11 as outlined in applicant exhibit number 1, and conditions 1C, 8, 12, and 13 will be modified as read into the record by Mr. Diaz-Campbell.
That sounds like it captured it. Is there a second? We have Vice Chair Bailey. Was that a second?
That's a second.
Okay. All right. Any discussion on that very complicated motion?
Yeah, not on the motion itself, but let me just thank the applicant's desire and interest in the pedestrian connectivity in this area. I obviously use this area pretty regularly. If you're going, and I'll just make one suggestion, if you're going to potentially later on signalize Testudo where it hits Campus Drive, right now the only way to cross over just right to the southeast of there has a signalized, or well, it's a signalized bike and pedestrian crossing where you press the button and it actually makes a really nice sound for people who are visually impaired, and it stops the traffic and it blinks. If you could do something like that for the pedestrian crossing, if you're looking at going onto the north side, or at least put in the infrastructure for it later on so it can be done that way. I think the one that's a little bit southeast of there to get across Campus Drive is extremely good and well done. And we don't have a lot of that around in this area that's really prioritizing pedestrian and bike safety in that area. So if you can think ahead about that, that would be much appreciated by myself, as well as I'm sure a lot of the people who are going to be living in that area down the road. So thank you.
Thank you, Commissioner. Any further discussion on the motion? Seeing none, I will call the roll. Commissioner Washington.
Vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
Vote aye.
Commissioner Giraldo is left, so I vote aye as well. The ayes have it 4-0. And thank you all. Thanks very much for this. We will be seeing you again in different versions of this. It's an exciting project. And thank you for your attention to this. Thank you also for the close collaboration with the City of College Park and the county. It's great to see, it really is. Thanks, everybody.
Thank you all. We appreciate it as well. Thank you.
Our final item is item 6. I believe, let me turn to Mr. Hunt, or maybe it's Mr. Heath, because I'm not sure that we're taking this up today. Staff?
Mr. Chairman, Mr. Heath does have something he wants to, as part of the presentation, but just something very brief.
Okay, so we're on item 6, preliminary plan of subdivision 4-22019 Daniels Park, and I'll turn to Mr. Heath.
Yes, thank you. Good afternoon, Mr. Chair, members of the board. For the record, Antoine Heath with the subdivision section. Staff is in receipt of a letter from the applicant's representative dated February 14th, 2023, requesting to withdraw this preliminary plan of subdivision application for 4-22019 Daniels Park from review and hearing. And this will conclude staff's presentation. Thank you.
Thank you, Mr. Heath. Ms. Coleman, do we need to take any action on that, or do we need to acknowledge that in any way, shape, or form, or is it simply the applicant's requested withdrawal and so we move on?
It's simply the applicant has requested that it's withdrawn. So it's just advising properly.
So without objection, Commissioners, it's withdrawn, and there is no further business before us that I am aware of. Mr. Hunt, is there anything that you have to bring us?
No additional items. I think you hit the nail on the head, Mr. Chairman. Have a great rest of your day.
Okay, so without objection, we are adjourned, and thanks, Commissioners.
Have a great rest of the day, all.
Thank you. Thank you.